Be ready, start. In order to satisfy ourselves, we had summoned the relevant record which has been produced by the learned additional chief standing counsel, and on a perusal thereof we find that after submission of the reply by the petitioner to the charge sheet, no date was fixed by the inquiry officer for holding any inquiry, nor any inquiry was held by him. Stop. No material has been produced before us by the learned additional chief standing counsel showing any inquiry having been held by the inquiry officer as is required under law. Stop. It appears that the inquiry officer has prepared and submitted the inquiry report straight away after submission of reply by the delinquent. Stop. The documents placed before us by the learned additional chief standing counsel reveal that the inquiry officer issued a letter dated 18/7/2011 annexing therewith the charge sheet to the petitioner seeking his reply to the same by 10/8/2011. Stop stanza. By the said letter, the petitioner was also required to inform as to whether he wanted any personal hearing and also if he wanted to examine and cross-examine any witness, then the name as also a brief note on the points on which such examination or cross-examination was required. Stop. It was stated that if the reply was not submitted, then it would be deemed that the petitioner had nothing to say in respect of the charges, and accordingly the inquiry would be conducted and the state government would be informed. Stop. The contention of the learned additional chief standing counsel that as the petitioner did not state in his reply that he wanted any personal hearing, nor did he mention the name of any person whom he wanted to examine or cross-examine, therefore the inquiry officer prepared the inquiry report and submitted the same before the state government. Stop. Learned additional chief standing counsel contends that sufficient compliance of the rules of procedure as prescribed under law has been made for imposing major punishment, and principles of natural justice were duly adhered to. Stop stanza. We are unable to accept the contention of the learned additional chief standing counsel. Stop. Even if the delinquent employee does not request for personal hearing, the burden of proving the charges normally being upon the department, the inquiry officer was under obligation to fix a date for such inquiry with information to the delinquent and to conduct inquiry wherein he was required to examine documentary as well as oral evidence in support of the charges. Stop. Even if the delinquent employee did not participate in the inquiry officer was duly bound to discharge his obligation as an inquiry officer of ascertaining the truth in respect of the charges leveled against him on the basis of evidence as to whether the same are proved against him or not. Stop. Even if the delinquent does not demand personal hearing or does not give the names of witnesses with brief synopsis of points on which he wishes to examine or cross-examine the witnesses, the inquiry officer is not absolved from fixing a date of inquiry with intimation to the delinquent. Stop stanza. In either eventuality, he is required to hold inquiry if delinquent is present, in his presence if he is absent ex parte. Stop. If oral evidence is referred in the charge sheet, same is required to be recorded, examined. If not, even then the documentary evidence is required to be examined in the light of the charges for ascertaining the truth in respect thereof. Stop. The delinquent is also entitled to be intimated the date for oral inquiry, wherein the inquiry officer should confront the delinquent with the charges and the evidence in support thereof, put relevant queries to him, elicit and record his replies, response, and respect thereof stop. Such oral inquiry is necessary as it gives an opportunity to the delinquent to explain his conduct and to the inquiry officer to have a better perspective of the controversy, as it is not always possible to discern the truth from written replies and documents which may not necessarily convey the complete truth. Stop stanza. Learned counsel for the appellant submitted that on 14th October 2009, this court in writ petition number 535 of 2009 has passed the order of status quo with regard to managing the affairs of the institution as on date, meaning thereby de facto situation regarding managing the affairs of the institution was directed to be maintained by the respective parties, and therefore the district inspector of schools Manipur was not at all justified in passing the order on 30th December 2009, clarifying that as the signature of Ram Lal has been attested on 3rd October 2009, the account would be operated by him, and when the contempt notice was issued and an opportunity was given to him to comply with the order, the district inspector of schools Manipur has rightly cancelled the order dated 30th December 2009, wide order dated 20th February 2010 stop. He further submitted that the learned single judge was not justified in staying the order dated 20th February 2010, which runs contrary to the order dated 14th October 2009 passed by this court. Stop stanza. Shri K.R. Sirohi, learned senior counsel, on the other hand, submitted that the present appellant, having challenged the order dated 3rd October 2009 passed by the district inspector of schools Manipur, whereby signature of Ramlal was attested by means of the writ petition, which was initially dismissed on merits, and in special appeal the appellant having got the special appeal and writ petition withdrawn without reserving any liberty or getting any permission to challenge the same in a fresh writ petition, is stopped from saying that the order dated 3rd October 2009 is of no significance. Stop. He also invited the attention of the court to the information given by the Treasury Officer Manipur under the Right to Information Act 2005, wide letter dated 18th February 2010, wherein it has been stated that the letter dated 3rd October 2009 issued by the District Inspector of Schools Manipur was received in the office of the Treasury Manipur on 12th October 2009, that is, much before the order dated 14th October 2009 had been passed by the court. Stop. According to him, as prior to 14th October 2009, the signature of Ramlal has been attested. The District Inspector of Schools Manipur has rightly clarified the same wide order dated 13th December 2009, and the cancellation of the order passed by the District Inspector of Schools Manipur is uncalled for, and the learned single judge has rightly stayed its operation. Stop stanza. We have given our thoughtful consideration to the various pleas raised by the learned counsel for the parties, and are of the considered opinion that the present appellant cannot challenge the validity of the order dated 3rd October 2009 in a collateral proceeding, in as much as for the reasons best known after the writ petition challenging the said order has been dismissed, and in the special appeal preferred by the appellant the writ petition and the special appeal have also been got dismissed as withdrawn without any liberty to file a fresh writ petition. Stop stanza. That being the position and in view of the legal position that the order dated 3rd October 2009 attesting the signature of Ramlal had come into existence and therefore he is entitled stop over.